Okay. Showcase. Haverhill on Clark versus Woods.
Good morning, Your Honor. I dive before the plaintiff and my clients.
Good morning, Your Honor. Tish Lee on behalf of Ms. Woods, and I believe Ms. Smith has an identical motion up. Are you planning to hear?
Why are you gracing us with your presence?
Oh, because I miss you, Your Honor.
Is that what it is?
I just, it's been so long, and
Yes.
YouTube is not the same as seeing you in person.
Yeah, I have to go places just to show people I exist outside of YouTube. All right. So I will also call the case of Haverhill on Clark versus.
Thank you, Your Honor. And both Ms. Woods and Ms. Smith are present. Well.
Okay.
Yeah.
All right. Go ahead.
So, Your Honor, this is our motion for summary disposition based on the short notice under the CARES Act. I know that the two of us have gone back and forth about this for a long, long time, Your Honor. You know my arguments and my position, but if you want me to spell them out, I can. But for the record, we did file our motion for summary disposition based on the fact that the demand for possession in both of these cases was only 7 days. And we believe the CARES Act requires that those notices, and because the notices were inadequate, that both of these matters should be dismissed for lack of jurisdiction under the Park Forest Doctrine, Park Forest at Blackman versus Smith. And so we filed that motion, and in response, plaintiff has argued that the CARES Act was essentially repealed by a HUD notice of interim final rule. And in our response, we argue essentially three things, three things: that the interim final rule was essentially revoked by HUD 2 weeks later, that it doesn't apply to the plaintiff's property because plaintiff's property is a low-income housing tax credit property governed by IRS Treasury rules and not HUD. And third, that essentially constitutionally you cannot repeal an act of Congress via administrative action by HUD.
Okay. I'm not even going to deal with that last one. This is
All right.
new world, but I get what you're saying. But
All right.
Okay. All right. Silence.
Yes. Your Honor, as the court knows, that both of these cases were filed as non-payment of rent cases. Essentially, the argument is a due process notice issue. Notice is the purpose of notice is to well inform the defendant or the other party of the claims and allegations against them, so that they can properly defend themselves or they can be afforded an opportunity to be heard in court. And we're now months in of these two cases. Multiple hearings have been had. Dispositive motions have been filed. Responses. Defendants have availed themselves of the court's jurisdiction, to the right to counsel, and the CARES Act essentially, respectfully, Judge, is a tactic. It's just a tactic. It's a stall tactic. It's used to delay the inevitable. This argument is not based on the merits of these cases. Not one conversation has been had regarding the merits of the cases. What is the defendant? Are the defendants able to pay? Are they seeking resources? Are they challenging the arrears? I don't know this because I haven't had any conversation regarding the merits of the case. Is this effective counsel or the effective use of this court's resources? I do not believe so, Your Honor, because at the end of the day, it is still, to brush this under the rug, to dismiss it would be contrary to judicial economy and what's in the best interest of both parties. It would be detrimental to the defendant. It would also be prejudicial to my client to delay this any further We are here. Defendants have just recently asked me for, sister counsel just recently asked me for ledgers. So now, okay, now we're getting on the merits of the case. So instead of understanding what the status is regarding the arrears, we're now still fighting over this due process issue, this CARES Act issue. And I mean, people have tenants have subsidies for a reason. They have it. I believe that they need it. And it is essential to preserve these subsidies, like tech properties, Your Honor. And part of effective counsel is to help them preserve these relationships and these subsidies. And
Also, when we were here the last time, if you recall, one of the things I said is that you may want to file a new notice.
we did do that, Your Honor.
Okay.
So, I mean, I think both are.
When does that, if it's a 30-day, when is that set to expire?
Actually, I believe it's already expired. And so instead of, my take on this, Judge, is even if a case was dismissed, it's still.
You're going to refile immediately with a new notice.
Say that again?
If these cases are dismissed, you're going to refile with a new notice.
Right, but my issue here, Your Honor, is it would be detrimental to the defendant. If preservation of these subsidies or these properties or this tenancy is crucial. Multiple filings, even if it results in a dismissal, still works against them. It shows that a case was filed against them in summary proceedings. Yes, it was dismissed, but then another case was filed. Instead of utilizing this time to maybe
but how does,
by way of a CD.
how does that? Okay. I'm not sure how that is detrimental necessarily to.
Well, because they could potentially risk losing their tenancy status. And sometimes, this is lifetime property. If it's lifetime, I believe that if they disqualify, I'm not sure if it's indefinite. But the risk of losing it alone is detrimental to the defendant. So I just don't understand why this is the route that counsel has decided to take on this when I would like to know, are there challenges to these arrears? Are they planning on paying? Are there resources being sought? Do they have financial assistance? I mean, these are important pieces of information that is crucial in resolving this case. You can't just brush it under the rug. And then what happens outside of court, Judge? They have a fiduciary relationship, landlord-tenant relationship that still exists. And are they going to offer their assistance to the defendants outside of court as well to resolve their arrears?
Well, I don't know that. What do you have to say to that, Ms. Lee?
Your Honor, we are the defendant's lawyers. We're acting in their interests. And we believe, essentially, the notice requirement is not just about a notice, it's about opportunity to cure. And so to have 30 days to pay instead of 7 days to avoid having a case filed against you is...
Right, but here's what the problem is right now. I disagree vehemently with your assessment of the jurisdiction of this court. You know that.
Yes, I know that, Your Honor.
And I disagree with Judge Conkey's ruling, which is not binding on me.
Yes, we understand that, Your Honor.
Because I don't think it confers that's not how jurisdiction is conferred in this court. And the approach is, frankly, from my standpoint, jurisdiction has probably been conveyed. The question is have you asserted, in essence, an affirmative defense that would lead the court to determine that plaintiff's case would be that is fatal to plaintiff's case?
Yes.
That's the way I look at it.
Yeah, we believe so, yeah.
And I get you guys disagree, but it doesn't matter. I'm the judge. So
to ask the court to exercise its discretion and authority, equitable jurisdiction authority, Your Honor, in determining what's in the best interest of judicial economy and fairness and what would be detrimental to the defendant and prejudicial to the plaintiff.
Well, but here's the thing. There's an interesting thing with affirmative defenses. They've asserted it. I've got a rule on that affirmative defense. That, I think, is where it then goes to, is there a way to salvage this without much else going on? And I don't know if defendants are interested in that at all.
Your Honor, we are interested in that.
So let me ask this part, because my belief is that the jurisdiction of the court has been done. And I'm not ruling on the affirmative defense as asserted as of yet. How much is owing on Woods?
Woods currently owes through August $4,188 in rent, $170 in the attorney fees and costs. That's just, we haven't asked for additional costs, Your Honor. And then $4,358 is the redemptive amount. The last payment,
4,300 what?
the last payment that we received on her behalf was on June 9th in 2026.
Okay. And on, hang on, please. And on Smith, how much is plaintiff claim is?
Yes, Judge, I'm showing rent to retain in the amount of $6,915 due knowing through August, 170 attorney fees and costs for a total of $7,085. Last payment received was on 7/1/2026. And I believe there was escrow, but I'm not sure if one has paid with escrow and the other has paid directly to my client.
I have in Miss. How come I do? So in Miss Smith's case, I have no escrow. And in Miss Wood's case, I have 1568 in escrow. Yes.
I just wanted to mention on behalf of Ms. Smith and Ms. Woods. For Ms. Woods, she paid escrow, I believe, for July and August to the court. And also,
When did she do that? Hang on. Yes, she did. So I have another 1568. Is that what you have?
yes, sir, you have 3136.
Thank you.
And Ms. Woods disputes the balance because they failed to credit her one of her money orders, and she has proof of that. And for Ms. Smith, she paid her July escrow directly to the landlord. She did, which we discussed.
We discussed that the last. I get it. But the balance you gave me is with that credit.
Yes, it is.
So, oh,
Again, no discussions about the merits of the case. If she offered or anyone offered.
look, stop. Everybody just stop. Everybody just stop. All I want to know is this. So, because here's just the practical reality. If I let them assert the affirmative defense, consider it fatal to the plaintiff's case, what ends up happening is the cases are dismissed. Then they're refiled, which seems to me is going to tack more court costs onto the defendant potentially at some point. So,
Your Honor.
folks, are you, real quick, Miss Smith or Miss Woods is what, about 1,000 some odd off from getting everything corrected?
Incorrect, though.
What is incorrect?
Balance that's remaining after you deduct the escrow payments is an amount that is incorrect because they failed to credit her a $500 money order, and then every
Okay, so let's say, okay, what I'm getting at is this. Let's say the money order is there. Let's say Somehow you got to litigate that. What my point is, Ms. Wood's tenancy can be preserved. It is so close to whatever. But I don't know whether or not you have an interest in that happening.
Your Honor, we do have an interest in that happening. They're our clients. And so what we propose is that this case be dismissed, that no court costs be assessed because it never should have been filed in the first place. And that
But you're not going to win that because I would be dismissing not on the basis that you view the CARES Act. You might be right if they never invoked the jurisdiction of this court. I do not believe that to be true. So.
And so you'd be dismissing on what grounds, Your Honor?
That you've asserted affirmative defense that's fatal to the plaintiff's case.
All right. And
How? Oh,
so just focusing on Ms. Wood's case for now, Your Honor,
yeah.
it's easily resolvable.
How
And
much?
we can resolve it before
500.
a case is filed, a new case is filed.
Well, maybe.
No, still.
If it's 500, so it's 500. That's at issue. Really? I mean, is that what we have?
Roughly?
Your Honor, plus addition of tons of late fees and so forth resulting from that failure. We've been having a lot of ledger problems at Haverhill. I think they're trying to correct their books. They've been moving around a lot of rents paid through to a security deposit ledger inappropriately. So this has been causing a lot of confusion for Ms. Woods as well as for many other tenants.
Your Honor,